Shane. Well, why don't you kick us off? What are we going to learn today?
Yeah, we've got quite a bit of information to cover as this upcoming year is not unusual in California for businesses. There's usually a whole new series of employment laws that are passed, and this year's no exception. So what we'll do, we're not going to get into all the changes in California employment law. There were many. Some of them are very specialized in nature, but I will get into the major changes that that'll affect pretty much all businesses, and these laws go into effect on January 1st. So we'll talk about what those new laws are and what businesses and company employers need to do in terms of making sure they're compliant as of January 1, so they don't get into trouble. A lot of these will require changes in hiring practices, as we'll see, and we can talk about what types of changes need to be made there. And then we'll also talk about this rise in harassment cases. Anybody that I think has a television or radio is probably bombarded with, or that just reads the news online, is bombarded with information about new harassment, high-profile harassment cases, especially in Hollywood and against politicians. And it seems like there's more and more of these, and they're on the rise and don't seem to be going away. So we'll talk about that and how businesses should handle harassment claims against maybe some of its more key employees, executives, or even owners of the business. Those can be really particularly problematic harassment claims because of who they're against within an organization. So we'll talk about how to deal with that.
And Shane, do you think the emphasis on all these high-profile cases is somehow affecting the landscape? I know the laws change every year, but do you think there's something different about this year because of those cases?
Well, I don't. There are new anti-harassment training requirements, although as we'll see, they don't necessarily focus on sexual harassment this year. As the slide shows here, they relate more to transgender rights and identity, gender expression, sexual orientation. But I do expect to see more claims as employees in particular, become emboldened based on what they're hearing in the news. And with movements like the hashtag #MeToo social media movement, I think what you'll see is employees emboldened to make claims. And historically, claim rates for sexual harassment are pretty surprisingly low. I mean, somewhere in the neighborhood of 50, 60, even close to 70%, some experts believe, of harassment claims never result in a complaint to the employer and never result in a lawsuit. So I think the uptake of this is that you'll see more claims as it's becoming more, as high-profile people become more vocal about it, and people feel strengthened by that voice.
Yeah, in fact, I heard something. I don't know if you heard this, Shane, but I read yesterday that in Washington, some 1,500 plus people signed a petition against some of the legislators and the harassment there. So it's hitting at the core of our government, it sounds like, too.
Yeah, and not even, beyond sexual harassment claims. I mean, just sexual abuse claims. I mean, that's been in the media lately, too. I mean, bordering on the criminal. And certainly when you have that, it definitely in the employment setting rises to the level of civil sexual harassment. If it's criminal, it's going to be civil harassment as well.
And what is the difference between those two? It might be helpful for people to understand that.
Well, civil sexual harassment is, with criminal. In the criminal arena, you're dealing more with an assault, usually, or a battery. I mean, you have to have put someone in fear of their personal safety. That's an assault. or you've actually unlawfully touched someone without their consent in a sexual way, and that will be, a sexual abuse type crime. In the civil arena, those things can happen, and they can be crimes, and those things would also violate various protections that employees have under the government code and the labor code. But the standard's lower for sexual harassment in the civil arena, and it can be verbal in nature. It can be, just making ongoing passes at a coworker, telling a subordinate that his or her job depends on submissing, so to speak, or making dirty jokes or showing pictures. So the standard is much lower. And there's also kind of a statute of limitations issue. I mean, I think a lot of people are surprised that they're hearing about all these sexual harassment claims, but the thought is, well, why did nobody do anything about it, or why aren't we seeing all these lawsuits in courts play out against these high-profile people? Well, in California, the statute of limitations for sexual harassment is 1 year. It's actually a pretty short statute when you think about it, when people have to go through this process and deal with it and decide if they're going to take legal action against an employer. They don't really have a lot of time to process what's happened to them and do that. So it's a very short statute of limitations. Criminal statute of limitations tend to be a lot longer. I don't know off the top of my head what it is. But it depends on the nature of the claim, if it's an assault or a battery, or if it gives rise to an actual sexual related crime. These tend to be much longer, but the burden of proof is higher. So district attorneys need a lot more evidence to prosecute those claims. So even though they have more time, it's harder to bring those claims. So that's why I think that explains in part why we see this rise in media attention and these people being outspoken about what has happened to them, but not necessarily seen the legal action against these individuals.
Right. And what about and it's not on the slide, but I think it's probably germane to now and in 2018, this idea that a non-disclosure agreement could be executed in such a way that it would preclude people from coming forward?
That's an interesting issue. And I think particularly in California, there would be serious question about the legality or the enforceability of a non-disclosure agreement that precludes an employee from enforcing his or her statutory rights, especially a pre-dispute agreement. Now, if a dispute arises and in the context of, for example, a settlement of even a pre-lawsuit settlement of a sexual harassment claim, the parties could certainly enter into a confidential settlement agreement where each agree that they won't discuss the terms of the settlement or what happened in the case, and will just give probably some brief statement that there was a dispute and it's been amicably resolved. But to enter into some type of, to try to enforce, and a lot of businesses have non-disclosure agreements and they have employees sign them at the outset that covers, confidential or proprietary company information. I don't think those would be applicable to sexual harassment claims. And if you tried to draft one up that said you can't disclose to the public if this happens to you, I've not seen that, but I think they would, courts would have a very difficult time agreeing to enforce those types of agreements.
Makes perfect sense.
Sure.
Let's talk a little bit about the displays. You mentioned the transgender rights. Tell us a little bit about what we need to do as employers to make sure we're complying with the notice rights and display rights and other things.
Yeah. So as you can see here, California, the first two things on this slide, the first two laws that were passed were anti-discrimination protections for veterans. This is pretty simple and straightforward. There's already existing law on that. This law, AB 1710, just expands that to prohibit employers from discriminating against veterans in the terms, conditions, or privileges of employment. That's pretty straightforward. The the new anti-harassment training requirements related to transgender rights and training. So what's supposed to happen is the DFEH, the Department of Fair Employment and Housing, will be preparing actually a poster that employers or businesses with 5 or more employees, and that's probably most businesses, has to display somewhere in a prominent place in their office or at their work site. And this will be a poster, again, that'll be developed by the Department of Fair Employment and Housing, and it'll relate to transgender rights. I don't know what it'll say yet, but it'll probably just explain to employees that it's unlawful for employers to discriminate against them based on being transgender or asserting their rights as a transgender person, that they can't be retaliated against if they complain about discrimination or harassment, things of that nature, and just provide them with general information. And employers should check at or around the first of the year a quick Google search on the Department of Fair Employment and Housing's website will probably pop up that poster fairly quickly. So it shouldn't be too hard to track down with just some internet searching.
What about places like Texas or other, North Carolina, other states? Do you see them doing similar things, or is this uniquely California?
It's possible. This is a uniquely California requirement. So if you're an out-of-state business that is not based in California and doesn't have any offices or employees in California, this law probably won't apply to you. In fact, many of these laws won't apply to you. Even if you're headquartered out of California, however, if you've got a work site here and you've got employees here, you do need to comply with these California laws. I will say that California is usually on the forefront when it comes to employee protections, and it wouldn't surprise me if there are very few jurisdictions or other states that have these types of notice requirements. And the other thing that's also expanded here is the training requirements. Under existing law, businesses with 50 or more employees must provide anti-harassment training, and it's usually focused on sexual harassment, to supervisors within 6 months of hire, and to all supervisors. They're required to have 2 hours of anti-harassment training every 2 years. Oftentimes we'll break that down into 1 hour every year, depending on how the employer does it. This just expands those training requirements to cover issues related to gender identity, gender expression, and sexual orientation. So it just expands what needs to be discussed at these anti-harassment training seminars. And employers should be careful to just say, oh, well, I'll do this myself, because the law does mandate that the training has to be conducted by an educator with knowledge and expertise in this area of the law, and to provide practical examples of what harassment might look like and how to stop it if you're the employer.
What about online training?
You can do online training, that's fine. I do anti-harassment training, and most of the time I will do it in person. I've just found it easier. But online training is completely acceptable. There are programs out there for that. So it is definitely a way to complete the training, yes.
Got it. So now, where do we go from here in terms of, do we jump to the criminal background, or you want to stay a little bit more on this, go a little deeper into this?
I think we're okay. One thing I just wanted to note here, and this probably doesn't apply to a lot of businesses maybe online here, but there's an expansion of wage liability for construction contractors, general contractors who hire subcontractors. They need to basically ensure that their subcontractors are paying the subcontractors' employees' wages, or the general contractors could be liable for that. And the reason I bring this up is there's just been an abundance of wage and hour litigation in California. And so I put this on the slide just to remind businesses that they really need to be vigilant and diligent in making sure that they're complying with California's tremendous number of wage and hour laws. Another law that was passed, or more power or authority was given to the Division of Labor Standards Enforcement, which is the state body that enforces wage laws. More power was given to them to go after businesses for wage violations. Traditionally, an employee usually had to make a complaint to the DLSE, to the Division of Labor Standards Enforcement, for them to become involved. If, however, the DLSE now finds reason on its own to go after a business, it can do so. So it may just hear a rumor, for example, or get an anonymous tip that a business is out of compliance with its wage law obligations, and now the DLSE has authority to start investigating those businesses and pursuing claims against them. So it's just a reminder for businesses to be hypervigilant.
Hang on a second, Shane. This is big. This is really big. Let me make sure I understand this. So if I'm a solar contractor in California and I use subcontractors, for example, to install the ground mount platforms, as the general, I'm now liable in 2018 for making sure that the subcontractors have labor that is being fairly paid and legal. Is that right?
Yes. I wouldn't say that just now that liability exists. There's always been a theory of what's called joint employer liability in California, where if it can be established that two companies really kind of control the employee, both could be liable, both severally and jointly liable for the wages of the employee. This statute just really, but there are things that need to be proved. The employee seeking to hold, the employee of the sub seeking to hold the general contractor liable will have to prove that he or she is being controlled by the general contractor. This statute just makes it easier for the employee. They can say, well, if the subcontractor that hired me can't pay me, I can go right to the direct contractor, as it's defined, or general contractor. So it is an expansion of liability. California has, over the recent years, has been extending liability in that way. For example, just last year, the legislature passed labor laws expanding wage liability from just corporations to managing agents of the corporation or owners of businesses. Traditionally, individual owners or officers of corporations or businesses weren't liable for unpaid wages, but California has extended liability to those people, and this is just another step in that process.
And this is only stateside, right? It doesn't affect any subcontractors that would be doing other work offshore, correct?
Yes, although I will say federal law has similar joint employer liability theories that employees can assert, but nothing quite like this, nothing so direct.
Got it. You mentioned arbitration agreements. Talk a little bit about that.
Oh, yes. So if this is particularly important for big businesses. If you have a large workforce, well, let me start here. It's very difficult to comply with the letter of the law to a T in California regarding wage payments. Oftentimes, if an employee takes a late lunch, or if you have a large workforce and it happens regularly, and employees just don't report it, that could create liability for the business without it really even knowing. And so this gives rise to potential wage claims, and potential wage claims on a large scale, like in a class action, where you have hundreds of employees coming after you for similar violations. Now, over the last several years, businesses have been able to effectively use arbitration agreements to stave off these types of class actions by having class action waivers, or a provision in an arbitration agreement that says, we won't fight over your wages, or we won't resolve our disputes in court in a class action. Instead, if you have a wage dispute, we're going to resolve it with you through arbitration on an individual basis. And we've been quite successful in having several class action lawsuits dismissed on this basis, which it results in a tremendous saving to the company. Right now, those types of agreements are being challenged. The issue is before the United States Supreme Court. All the attorneys that do this type of work are waiting with bated breath to see what the Supreme Court will do, whether it will enforce or allow businesses to enforce these types of agreements. The thinking is the Supreme Court will permit these types of agreements to stand, but we need to wait and see what the decision is, so stay tuned.
And I think it might be helpful for those on the webinar to explain how these class action suits work. For example, we've seen more than a few where it is a law firm that is going after a big bucket of money and goes and hunts for people to join the class action suit. So each participant gets a relatively small amount, but they get a relatively large amount. Yeah.
These class actions tend to often be about the attorney's fees. You may settle, and the amount each individual employee gets can be very small. For example, if they can find an employee who works at a business with 300 other employees, and there was a problem with the business's meal period policy, or a technical problem with the rest period policy, that enables the attorney who now has this one client who might have a couple $100, maybe a couple $1,000 at the most claim against the business to say, well, we're going to sue on behalf of this person and on behalf of the 300-person workforce, even if they don't know and even if they didn't want to bring a claim. Too bad. We're bringing a claim on behalf of all of them. And so now you have a $1,000 claim that's multiplied by 300 employees, and the plaintiff's attorney gets his or her attorney's fees for prosecuting that case, which can add up very, very quickly. I mean, many of these cases, the attorney's fees are well in excess of six figures, oftentimes over $1 million. So these cases, if the business doesn't have a valid arbitration agreement with a class action waiver, they're tremendously costly. And these are liabilities that companies in California pretty much cannot insure against. You can purchase insurance to cover for a lot of discrimination and harassment claims, but most insurance companies do not provide coverage for wage claims. So it's just all the more important to make sure you're doing everything to comply with the labor code regarding payment of wages, and to seriously consider having your employees execute enforceable arbitration agreements if you don't already use them.
That's a great tip, and those of us that are HR leaders or business leaders can certainly take note, because we all certainly want to avoid that. Let's shift now and talk about some of the criminal background changes.
Sure.
Especially, as we look at some of the horrible things that have been happening with people purchasing guns, the idea of background checks is front and center for many, many people.
Yeah, no, that's a really good point. So there's been a movement in recent years, and it really started on the local level, in different cities with the passage of city ordinances to ban employers from asking employees about their criminal history before making an offer of employment. And the thought behind the law is that they don't want employers asking about criminal history until they've made a determination as to whether this person's even qualified for the job. And I was looking at some statistics. It's really kind of a second chance law. In San Francisco, in fact, they passed an ordinance in 2014. It's called the Fair Chance Ordinance. And I was looking at some statistics this morning that showed that 7 million Californians, adults in California, have arrest or conviction history, have some type of arrest record or a conviction history. That's nearly 1 in 3 adults. It's actually, I was surprised to see that it's that high. So that's a large number of the workforce that if an employer, and in fact that was built in when the legislature drafted this law. That was part of the legislative findings. Those were the numbers that the legislature declared, and so I'm assuming those statistics are probably pretty valid. But yeah, the purpose is, let's not disenfranchise this entire population and create hard economic opportunities for these individuals. Let's give them a second chance. Whether this turns out to be a prudent move or not, we'll see. But really what the law does, and the takeaway, again, it applies to most businesses. If you have 5 or more employees, the company is precluded from asking the employee about his or her criminal conviction history until a conditional offer of employment is made. So the ban the box phrase, that really comes from, employment applications used to have, these boxes, check this box if you've been convicted of a crime, or something to that extent. So that's where the ban the box phrase came from. So businesses need to go back to...
What about banks? What about banks and places where if a bank knowingly hires someone with a criminal history, act of dishonesty, I think it's still a fine of $1 million a day.
Yeah, there are exceptions built into the law. If you're a business and you're required as a matter of law to do a pre-screening background check, there are exceptions for that. And it doesn't just specify to banks. It's a pretty broad exception built into the law that specifies, and this law applies unless there are other really more specific laws. In fact, the phrase is this section, the law does not apply in any of the following circumstances to a position for which a state or local agency, that applies to state or local agencies for background checks, but it also applies to private employers too, to a position where an employee is, or where an employer or an agent thereof is required by state, federal, or local law to conduct a criminal background check for employment purposes, or to restrict employment based on criminal history. So there's a pretty broad exception. If you're a business and you're required under a special law to do a pre-employment background check, then this won't apply to you. Otherwise, you can't have the box on your employment application asking an employee if he or she's been convicted of a crime. During an employment interview, you can't ask whether the employee has been convicted of a crime. You can't inquire into whether the employee has a criminal history until you make a conditional offer of an employment. So that means you can't even get the application and do a Google search and start looking, I wonder if this person has a background check. Nobody, or a criminal background, nobody will know if I Google it. Maybe they won't. Maybe they'll find out somehow. But it's a very broad ban on looking into or inquiring about criminal history of applicants. Now, once an offer of employment is extended, the business can then do a criminal background check. But if the business ultimately decides after doing the background and finding some criminal history that it wants to revoke that offer of employment, there's a whole series of steps that the business then has to follow under the law.
Yeah, it seems like it's just kicking the problem down the street a little in my mind. I mean, we all understand, people who've done something and it's on their record, it shouldn't be held against them if it doesn't have any applicability to the job and who they are. I think everybody gets that. But it seems like it's just pushing it down the track. It's not actually changing the decision.
I think that's right. But what it does is it brings to the forefront, and it really creates a written record that this person is not being hired because of his or her criminal history. Whereas in the past, if the background check was done before the conditional offer of employment was made, the employer could then later say that there were a lot of reasons why they didn't hire this person. It wasn't just because of their criminal history. You know, we didn't think this person was the most qualified, and we didn't think this, and we thought that, and also, oh, by the way, they had a criminal history. This will force upon the business to make the decision that, well, we offered this person the job, and oh, we found a criminal history, so now we're taking that away. It really highlights why the decision is being made. And once that happens, the employer has an obligation to engage in this, what's called individualized assessment of this person and their background before making the final decision to revoke the offer of employment. And what that things that the employer has to consider during that individualized assessment. In other words, a business can't have just a general blanket rule that we don't hire people with felonies or we don't hire people with these types of convictions. It has to look at that individual, look at the conviction, consider the nature and gravity of it, the offense, you know, how long ago was it, has this person been rehabilitated, and it has to base its decision on kind of the totality of those circumstances. And then it has to notify the candidate, the applicant, that the conditional offer of employment is being revoked, and it has to give that person an opportunity to respond, kind of state his or her case, explain why the information in the background check report, which has to be provided to the employee, might be incorrect, and allow them to make their case. And all of this should be done in writing. Certainly the notification to the employee has to be in a written letter, but even the decision-making process should be in writing. And then after the employee has an opportunity to respond, the business can make its one and final decision. So it really creates this, frankly, burdensome process for businesses when they decide to revoke an offer of employment made to someone who ultimately has a criminal history.
So it sounds like,
whereas the process was so much where it was a lot easier before this law, an employer could just say, okay, we're not going to offer employment, and there was no explanation needed, no defense could be provided. It was just they have a criminal history and we're not hiring them.
So it sounds like the sort of the safest route is to make sure that we, as employers, give everybody a fair chance. Just don't even think about this unless it actually applies to the job. For example, someone in finance and accounting, I would want to know if there was a history of crime in finance and accounting, for example. But beyond that, maybe just steer away from that as a requirement. Is that what your recommendation is?
I think that's right. I think it really depends on the nature of the job, and the labor code does have some restrictions on the scope and extent of background checks in California and what types of businesses can seek background information or credit history, things like that. I mean, this is a little bit of a different issue. But unless it's critical that an employee not have a certain type of conviction, or unless it's maybe very recent, it is presenting to be somewhat of a third rail.
Well, it's interesting too, Shane, and from the hiring standpoint, we see all the time where people, particularly managers and HR people, will set up requirements that have nothing to do with the job, but make it easy for them to cut a big pool down to a smaller pool, like must have a master's degree.
Mm-hmm.
Most jobs don't require a master's degree, and the ones where it says it's absolutely required, it's only because the manager has a master's degree, for example. Still legal to do, and in this case, what I'm hearing you say is when it relates to something like a conviction, then it's too easy in some ways, right? Unless it relates to the job, like you said.
Yeah. So, I mean, just some practical advice. I mean, if there's a standing policy in the business, especially something like in a handbook or something, saying that if you have a felony conviction, you cannot be employed here, or if you've been convicted of a felony within the last 3 years, you can't be employed here, or your employment will be terminated if we find out about it. That would just be now a facially invalid, unlawful policy and should be changed and removed from writing. The law now is, if after making an employment offer you find out about a conviction, that even if it's relevant to the job and the business still has to make this so-called individualized assessment and look at this person and their circumstances and the nature of the conviction. So it just really puts the company to task in terms of sitting down and thinking, okay, let's really look at this person, why the conviction happened, the special circumstances surrounding it, and then we'll decide whether or not to revoke the offer of employment. So
this is where we've got to change, really make sure our managers know what's going on here.
Yes. Anyone that's doing hiring, they need to know that these questions are off limits. That employees shouldn't even really be presented with background check forms until they're provided with an offer letter or at least a verbal offer of employment. So the businesses hiring personnel should not be presenting background check forms along with applications, for example. And then if that person is in charge of hiring throughout, they should know that if they do uncover a criminal history, they need to take additional steps if they decide ultimately to revoke the offer of employment because of that, or if they're thinking about it. Now, if ultimately they see the background report and they think, well, this isn't a big deal, we're going to hire the person anyways, job's done, move on, hire the person, and
Great
go forward.
Practical advice. Remove it from the handbook. Train the managers and integrating the interview team, and to the extent possible, don't even include it as part of your decision-making process.
Yes.
What about salary history?
We're in a similar new area. Recently, there's been a movement. Again, this started in local jurisdictions. I think New York was one of the first cities to ban salary history inquiries. San Francisco passed legislation over this summer that actually goes into effect next summer, and California jumped on the bandwagon. I think Oregon, there's a handful of a few other states that ban salary history inquiries, but California is definitely on the forefront here. And so this is just an expansion of the Equal Pay Act, and we've talked about that before in these seminars. But the Equal Pay Act is employers are really have an affirmative obligation to ensure that employees of different genders and now races and even ethnicities are being paid the same for pretty much substantially similar work. And the ban on salary history inquiries, and just stepping back one more foot, last year the Equal Pay Act was expanded to preclude employers from considering the employees or candidates' prior salary in determining, or as a sole basis for determining what that employee's salary would be at the new job. And that was, again, to try to stop this perpetuation of gender pay inequality based on, well, if that person was paid less at a prior job, that's what they'll take here. This takes that the next step, and now as a business, you can't even ask what the employee made at his or her prior jobs. And it's very common for businesses to have on employment applications, state your employment history, the name of the employer, who was your supervisor, give me a telephone number, and what was your salary. And the thinking was, well, businesses wanted to know that because they wanted to know what this employee expected and what they could get away with paying them.
And you can still ask what you expect, right? You can still ask your salary expectations.
You can, but I would be very careful with that because it doesn't really matter anymore. And as I said, under the Equal Pay Act, it doesn't matter what the employee got at the last job, and now it doesn't even really matter what the employee expects. The question is the business, is the company paying employees of different genders basically the same amount for substantially similar work? Now, there are reasons to pay people differently, but there needs to be merit or a business justification behind that. Maybe the person has certain licenses that the other individual doesn't have. Maybe there's a seniority issue or production bonuses, things like that. But it can't just be based on what the employee. I mean, if a business starts making its pay decisions based on employee expectations, that could most certainly result in pay inequity, and the company could be liable for that. And the defense would be, well, we paid this individual what he or she wanted. Well, it doesn't really matter. And part of the Equal Pay Act was part of the reasoning behind it was this theory that, in negotiations, and I don't know if this is true or not, but the legislation behind it was that men would negotiate harder than women in regarding their pay and jobs, and so if the woman's job, if her pay was based on prior salary, where maybe she didn't negotiate as hard as a male counterpart, that's just going to lead to pay inequity if the employer can keep using that past number. So I think even inquiring into expectation is potentially problematic. And what's more is, under the new law, under the expansion of this Equal Pay Act and the ban on salary history inquiries, is employers now have to provide applicants with a pay scale range if they ask for it. So you really not only can't base pay on an applicant's prior history. If the employee says, well, what's the pay range for this job, you have to provide that. So you really businesses really need to start thinking about what's the value of this position. We need to really look for good qualified candidates, and I know you guys can help them do that, and narrow out and winnow out who the worst and the best are. And then we need to decide what's the value of this position and what are we willing to pay anyone that fits within our qualifications. I mean, that's what needs to be done.
Yep. Perfect advice. And to summarize, pay for the position, not the person. And there's some variation in that range based on, like you said, if they have special experience or skills that are unique. But I have personally seen certain individuals demand more and watch them get it. And others don't demand more, and they don't get it. But there wasn't a rational decision by the company. It was an effort by the employee. So, in the interest of time, I think we should probably move on to.
Let me I want to mention there's one more kind of major legislation that passed is the new Parental Leave Act. Now in California, businesses with 20 to 49 employees have to provide 12 weeks of unpaid job-protected parental bonding leave to employees. So this is quite a major shift in protected leave law in California. In the past, up until what will be January 1st, employers really didn't need to provide this 12-week protected leave period to new parents, and it even applies beyond parenting. It can be if an employee needs to take care of a child or a spouse, it needs to take care of their serious health condition. That usually only applied to businesses with 50 employees or more. So this greatly expands the law. Now we'll see how.
Shane, and to be clear, that doesn't mean the company has to pay them full time for those 12 weeks, correct?
No. As I said, it's unpaid leave. It just needs to be job-protected leave. I think most businesses try to provide employees with unpaid leave for parental bonding purposes. But if the business couldn't, it didn't have to, and it could say, look, we're sorry, but we really need someone to fill your position, and once we hire that person, we can't just fire them to bring you back. Businesses just can't be so lax in making those types of decisions going forward. They really need to make sure that, if we're between 20 and 49 employees and an employee needs time off for parental bonding or to care for a serious medical condition of a loved one, we need to provide that time, and we need to make sure that 12 weeks from now, that job is here waiting for that person when they come back. But again, no, it's not paid leave.
And for all you on the call, I can understand perfectly, having run companies that are 20 to 49 employees, having one person out for 3 months is a big deal.
Yes.
So you need to be ready for this and be creative. You'll have the salary dollars to potentially get a consultant or some other workaround, but it could impact your business pretty dramatically if you have a business in the 20 to 49 employee range.
Yeah.
How about safety rules?
This I think we can cover very quickly. This applies primarily to manufacturers of a variety of designated products, and those products that might be considered carcinogenic. It applies to mainly certain consumer products, air care products, cleaning, polishing products. If you're a manufacturer, there's all sorts of new kind of rules about providing employees with information about the types of materials they're dealing with. The law also extends to employers that have some of these materials at their work sites, and all it really requires is that employers provide material data safety sheets about the products that our employees are dealing with. I think a quick, easy way to figure out whether the law applies, or if you've got products at your work site that require employees be notified about them, just Google SB 258, and one of the top hits will be kind of the legislation, and you can see that there's a list of designated products that employers may need to be concerned about.
Perfect. The only other question I have on this is, on the graph on the right, there's 408 deaths from professional and business services. Is that from boredom? How do you get hurt there?
Yeah, it could be. I don't know if workers' comp covers that.
Yeah. So what about hiring? Let's talk about hiring a little bit. So we talked about
I think
ask for the salary.
Yeah, I think we've covered some of this. We might be able to go through it fairly quickly. I mean, in terms of new hiring practices with the ban the box law and the ban of the salary history inquiries, go hang up the phone and go check your employment applications. And if they have this type of stuff on them, get them revised. We have standard form applications that are California compliant. I'm sure a lot of places do. Go get one, or modify your own to just delete any questions about criminal convictions or salary history. With background checks, if this is important for your business, start coming up with a plan on how to deal with this. Establish new policies and practices, as we discussed. Hire or train your hiring personnel, your HR personnel, about the fact that they can't inquire or search for this type of information until after a conditional offer of employment's made. If you don't use offer letters to provide applicants with a job offer, seriously consider creating a template for a job offer. Again, this is something we can easily do. And that will create the written record that, okay, we've now made a job offer and we can start this background check process. And if something does come up, make sure you're doing this individualized assessment and you have staff that are trained on how to do that, on what's important, on what to look for, and on making sure that they're sending the proper notice to the employee if a job is being revoked, and giving that employee at least the 5 days that he or she may need to respond about the conviction.
Got it. So just from a tools standpoint, is there an application that people can get access to that would be considered compliant at no cost, or is there a cost? How does that work?
I would be surprised right now if there's anything out there, simply because this is so new. I mean, for businesses in Los Angeles or San Francisco where there have been laws like this for some time, there may be. We do have fairly standardized forms which we can provide at a fairly nominal cost that deal with what type of notice has to go to an employee if a decision is being made to revoke an offer of employment based on a criminal history. There's lots out there. A lot of businesses provide these. Background check companies probably have these types of standard forms. But the key for the business is to just make sure and ask when they're getting these forms from these resources to ask, does this comply with California's new laws regarding criminal background checks, and is this compliant? Because it's going to take some legal know-how to draft the right kind of notice if ultimately the business wants to revoke a conditional offer of employment.
So
now, I think going forward into 2018, I think there will be more resources out there, and it'll be easier to come by. Right now, I think they're probably scarce. And for a business, unless you've got a very experienced HR person or an in-house legal department, it may be wise to consult counsel or to at least start conferring with the company that you pay to do your background checks. I mean, most businesses don't do their own background checks. They have companies that do this, and if they're not jumping on this, maybe it's time to find a new background check company.
Thank you, Shane. What we'll do for those of you listening is we will work with Shane to figure out either links to get to them through Shane's company, other places, in conjunction with the slide deck you're seeing, so that it's one stop to get the things you need without you having to hunt around for them, to the extent that we can. We talked about hiring practices, salary inquiries.
Yeah, I think we talked about that a little bit. Just making sure not to ask the wrong questions. Setting salary ranges for positions, that's something that should be fairly easy for most businesses to do. And maybe now is a good time to do a self-audit, to look at your workforce and determine, are we paying people, the same if they're doing the same jobs and basically have the same qualifications? Are there gender pay disparities within our organization? Are there racial pay disparities or ethnic pay disparities within our organizations? If there are, those should be immediately corrected. And maybe start by saying, okay, we have these positions, and here's what we think the appropriate salary range is, and here's why we would think someone would be entitled to the lower salary range. Here's what qualifications someone might need to have to hit the middle salary range, and here's the qualifications for the higher salary range. Set this objective criteria, and I think that'll go a long way in putting the business directly in compliance with the Equal Pay Act. I don't think there's any need to hire experts or lawyers for this. It's just a matter of setting a salary range for a position and coming up with business justifications as to why that employees' pay may vary within that range.
It's also, I want to make sure that everybody knows that we actually have resources that give us localized, regional, and national salary comparison data. So we have that at our fingertips, and we work with companies to get it to them at little or no extra charge as part of what we do in our engagements, because we want to make sure that they don't get in trouble here. Harassment claims.
Harassment claims. Thankfully we kind of hit on this a bit at the beginning of the presentation. As I said, more and more claims are on the rise. People are hearing more about them because of the public outcry, the publicity. So I would expect to see, despite the enactment of tough laws, the legislature's amending of those laws to make penalties harsher and to make access to courts easier, I think we will see more claims as people become, again, emboldened by hearing about the experiences of, famous people, celebrities, or hearing people having the strength to come out about what's happening to them. Now, as I touched on, this gets particularly sticky when a key owner or executive or personnel within the business are accused of harassment. I think the key to remember is the business, regardless of who's being accused, needs to conduct a fair, timely, and thorough investigation, even if it's the company owner. That employee can't be led to believe that this is going to be blown off because, I'm making a claim against the owner of the business or against one of the rainmakers. The HR professional or whoever fields this complaint needs to ensure the employee, we're going to take this seriously, and in many times it'll probably be appropriate, in order to avoid any kind of appearance of a conflict, to hire an outside firm to do the investigation and reach a conclusion.
Got it. Okay, so we are actually at the end of our time. So why don't we wrap it up? And I guess this is a place, Shane, to just tell a little bit about what Long and Levit do.
Yeah. So as was stated at the introduction, we provide employment counseling for businesses of all sizes, from just a handful of employees to companies with hundreds or thousands of employees. It's a full-service counseling. We'll provide written policies. We'll update handbooks. We'll provide management policies. We'll provide counseling on how to handle these types of claims if they're made against your business. And what's more, we actually handle the litigation of these claims, the defense of these claims, if wage claims are brought against your business, or if a lawsuit or a claim is filed for harassment or discrimination. We handle those as well. So it is really kind of a one-stop shop. And I like to think we're pretty good at what we do.
Fantastic. And HireMojo is a hiring automation platform. Think of it as a recruiter bot. We buy in bulk from everybody for job distribution, marketing, candidate identification, direct sourcing, and the HireMojo recruiter bot named Mo does most of the work that is probably burning up the company's employee time finding and screening candidates. So it's probably the easiest way to make hires. It eliminates a whole host of other contracts with everything from applicant tracking systems to LinkedIn contracts to Monster, Career Builder. You name it, it's all thrown in, and it's super easy to use. Our mission is really simple. We want to help the 6 million jobs that are open get filled fast. And the fact that a third of them have been open more than 90 days we think is criminal. So we're on a mission to make sure that your jobs get filled fast with really great people and do so legally. And with that, I think that it's a wrap. Shane, thank you. Awesome job. And
thank you so much.
All of you listening, we are going to post this to the extent that we can include either samples of the self-audit, the anti-harassment policy, arbitration agreements, generalized things, we will do that, and or show you where to get those from Shane and his company. Thank you, everyone, and have a wonderful day.
Thank you.